The next case to come before the court is Dyck-O'Neal Inc. v. Mike Kozlina. Each party will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time for rebuttal, let me know because I'll keep track of the time and I'll try to alert you when you go into your rebuttal time. The arguments are being recorded, so please stay behind the podium, keep your voices up, introduce yourselves. You should not use the names of children or minors or victims should that be relevant to your argument. You can refer to those folks with initials or generic terms. We have read your briefs and we're ready to proceed when you are, so I would just ask appellant, do you want to reserve time?
Yes, Your Honor, 5 minutes, please.
Very well, then you may start when you are ready to go.
Thank you, Your Honor. Your Honors, counsel, may it please the court, Attorney Sarah Ogden for defendant appellant Mike Kozlina. Your Honors, the facts of this matter are not in dispute. Instead, the issue in this matter is whether the statute of limitation has lapsed, which turns on when plaintiff appellee Dyck-O'Neal accelerated a note signed by Mike Kozlina. Since Your Honors have read the briefs, you are aware that the note was signed alongside a mortgage in 2002. Mr. Kozlina admits that his last payment was made November 9th, 2007, and thereafter he defaulted. Dyck-O'Neal purchased the note 3 years later and sent a series of letters from 2011 through 2015 indicating that the entire amount, principal, interest, and fees, which totaled some $86,000 or $88,000, was presently due and owing. In January of 22, notwithstanding demanding the entire payment, Dyck-O'Neal sent a letter entitled Notice of Intent to Accelerate, stating that the amount necessary to bring the loan current was some $57,000 and giving 30 days to cure. Receiving no payment, they filed the underlying action, complaint for money judgment. Both sides filed motions for summary judgment, and the trial court found for Dyck-O'Neal. The trial court based its decision on determining that the acceleration that occurred with the filing of the action. Mr. Kozlina argues that that acceleration occurred much earlier, as indicated in the July 30th, 2014 letter. The statute of limitations for an action on a promissory note is found in Ohio Revised Code 1303.16a and provides that an action must be brought 6 years after acceleration. Acceleration is not defined in the note, nor is it defined by the statute. So we look to the plain meaning of the word. Black's Law Dictionary defines it as the advancement of a loan's maturity date so that the payment of the entire debt is due immediately. And that is exactly what Dyck-O'Neal indicated in their July 30th, 2014 letter. That letter states that the amount owed as of the date of this letter, which includes principal, interest, and fees, is principal, $45,000 and change, interest, $39,000 and change, fees of approximately $1,300, for a total of $86,233.81. Likewise, in the November 2nd, 2015 letter sent by Dyck-O'Neal to Mr. Kozlina, that letter states that his account is past due, asks for payment to be remitted, and states that the amount owing as of the date of this letter is some $88,000. In denying Mr. Kozlina's motion for summary judgment, the trial court reasoned that these letters did not have the language set forth in the note in Section 6C, that is, giving 30 days notice of intent to accelerate, stating the amount to make current, and advising that acceleration would occur in the future. However, in so deciding, the trial court misconstrues Section 6C and the meaning of the word acceleration. The prevailing case law has consistently found that such notices of intent to accelerate are not evidence of acceleration themselves. A fact I think we're all in agreement with. Thus, even if the court had used that language in those July 30th letters, that would not have been acceleration. However, the language of Section 6C is permissive, not mandatory. It states that if the borrower is in default, the lender may send a written notice, and it may require them to pay the amount, the full amount due. It is not required. In fact, Section 6D states that even if the lender does not require the borrower to pay immediately as described in Section 6C, it will have the right to do so at a later time. In other words, the note gives the lender the option to send a notice of intent to accelerate prior to acceleration, but does not require it. Several principles surrounding this issue have been consistently adopted by Ohio courts, including that acceleration requires some affirmative action on the part of the lender more than a simple default. A 2015 11th District case, Bank of New York Mellon v. DiPizio, states that when acceleration of the total unpaid debt is optional on the part of the holder of the note, as it is here, the holder has given no indication to the debtor that the entire balance is presently due, then the cause of action does not accrue until that balance is due pursuant to the particular note, or the holder has notified the debtor of an earlier date. However, that modifying phrase in the middle there, that the holder has given no indication to the debtor that the entire amount is presently due, is what has happened in this case. Those letters, that July 30th, 2014 letter, and again in the November 2nd, 2015 letter, both indicate that the entire balance was presently due. The letter does not use the word acceleration or immediately. It does not need to. That case, DiPizio talks about how you do not need to use the word acceleration to have acceleration, as a filing of an action can be evidence of acceleration. The letter does, however, unequivocally state that payment of the entire debt, principal, interest, and fees is owed as of the date of the letter. And likewise, the 2015 letter demands payment and states that the amount owing is some $88,000. Mr. Kozlina does not dispute that acceleration generally requires a separate act, aside from the mere failure to meet the due date. He argues that Dyck-O'Neal clearly indicated to him that the entire amount was due and owing as of July 30th, 2014. In other words, as of that date, Dyck-O'Neal considered the note accelerated. The fact that Dyck-O'Neal chose not to give him notice of intent to accelerate prior to that letter does not mean that acceleration did not occur. And because that letter indicated that Dyck-O'Neal considered that note accelerated, the statute of limitations began to run as of July 30th, 2014, and must have been brought by July 30th, 2020, or be barred. Dyck-O'Neal filed in February of 22 after the statute of limitations had run out. Therefore, the trial court erred in denying his motion for summary judgment and granting Dyck-O'Neal's motion for summary judgment. We would ask that this court reverse the Summit County Court of Common Pleas order, enter judgment granting Mr. Kozlina's motion for summary judgment, or remand with instructions to do so. Are there any questions for this one?
Hearing none. And I don't remember if you actually, you did reserve
I did
time.
reserve.
Yeah, okay. You'll have your full time for rebuttal.
Thank you, Your Honor.
Good morning, Your Honors. Attorney Susanna Pastor for Plaintiff Appellee Dyck-O'Neal. Counsel. I'm going to start by addressing the appellant's arguments briefly, and then move on to my argument and its principle. First of all, the appellant has spent a great amount of time addressing the July 30th, 2014 letter, stating that this letter in itself was the principal acceleration letter. First of all, this letter is not an acceleration letter. This letter, the July 13, 2014 letter, was neither a default letter nor was it an acceleration letter. This letter in no way demands payment, and it is definitely not an acceleration letter. If the court looks to this letter simply was a letter that talks about documents that support the debt owed to Dyck-O'Neal. Specifically, the letter says, enclosed are copies of the documents that support the debt owed to Dyck-O'Neal. The amount owed as of the date of this letter, which includes principal, interest, and fees, if applicable, is, and the letter goes on to address what is owed at the time. It also goes on to address contact information, and that is simply that. It doesn't address any type of demand for payment. It doesn't address any type of acceleration of debt. This letter could have been a request for documents. It could have been a request for what the balance was at that time. This letter could have been a letter that was response to something that the defendant appellant had requested. It could have been something that Dyck-O'Neal had sent to the defendant appellant based on taking over the debt. This in no way was even a default letter. It certainly wasn't an acceleration letter. If the court decides to treat this letter as an acceleration letter, anytime someone calls in and requests their balance or requests a payoff, then at that point, this letter, for anyone's account, will be treated as an acceleration letter, and everyone's debt will be accelerated at that point. Then that will trigger an acceleration of debts across the board for everyone's debts, and it would most certainly not be something that this court would want to do for debts going forward. So I'm going to leave it at that and then continue on to my argument and circle back around to that. The demand letter that plaintiff appellant sent to defendant appellant was dated January 6, 2022. This was the first demand letter that acted as the acceleration letter. This accomplished the acceleration letter, and then the complaint was filed thereafter on February 17, 2022. This is what accomplished the acceleration, was the filing of the complaint. The January 6, 2022 demand letter stated at that point that $45,749.66 plus interest was due and owing at that time. This actually demanded payment and was what, along with the filing of the complaint, that accelerated the debt. This is what accelerated the debt under this note and mortgage. And we're talking about not just a note, but a mortgage. If the court looks to the note, and specifically Section 6 and Section 10, we're talking about not only a note, but a mortgage. The mortgage wasn't attached to the complaint, but there is a mortgage that is at stake in this case. And the mortgage is incorporated into the note. And if you look to Section 10, the mortgage is as important as is the note. The mortgage, even though it wasn't foreclosed on in this case, the mortgage is incorporated into the note in Section 10 because the note and the mortgage were signed and executed on the same date. And the mortgage addresses acceleration just as much as the note does, and probably more so than the note. And acceleration in the mortgage, as this court knows, is probably more important than even that is addressed in the note. At Section 10, the note specifically says, this note is a uniform instrument with limited variations in some jurisdictions. In addition to the protections given to the note, holder under this note, a mortgage, deed of trust, or security deed dated the same date as this note protects the note holder from possible losses which might result if I do not keep the promises which I make in this note. That security instrument describes how and under what conditions I may be required to make immediate payment in full of all amounts I owe under this note, and it goes on to address those. The mortgage was incorporated into this note, and so acceleration addressed in the mortgage is incorporated into the note. And so when the defendant appellant talks about acceleration not being addressed in the note, that's simply not correct, because the acceleration that's addressed in the mortgage is incorporated into the note. Going on. Even though the subject note may not necessarily speak about automatic acceleration, the filing of the complaint did accelerate the note. We also have acceleration that was addressed in the mortgage. We have the note which addresses default at section 6. We also have the section 6, section 6C. We have section 6D, which talks about default letters being sent to the defendant, which in this particular case, there were numerous letters that were sent to the defendant that required payment, which he didn't make, but letters were sent to him nonetheless. And the July 30, 2014 letter, which, as I mentioned before, was neither a default letter nor an acceleration letter. It was just simply another letter sent to the defendant. Did not require payment, did not require acceleration. It was just a letter along with all the other letters sent to the defendant. The actual acceleration letter or the acceleration occurred with the filing of the complaint. Does the court have any questions for me?
Hearing none.
Okay, I have nothing further.
Thank you, counsel.
Thank you.
To address counsel's argument that anytime a borrower calls in and requests a balance, then those notices would be considered acceleration. That's simply not true. The lenders draft those notices. If they wish to make it clear that they do not consider them accelerated, they can simply state such. They can state the amount necessary to make the amount current. The letter that was sent stated that the entire amount owing as of the date of that letter was the entire principal, interest, and fees. In fact, in counsel's App.No's brief on page 7, they state that the July 30th, 2014 letter advises defendant appellant of the balance currently due at the time and provides supporting documentation to the same. It is a letter that is indicating to the borrower that the entire amount is presently due and owing. That is the definition of acceleration. As to section 10 of the note, I would point out that section 10 applies only if the lender has exercised the option to accelerate the note due to a sale or transfer of an interest in the property without the lender's consent. What is before the court is a note which does not provide the definition of acceleration, does not address when it is considered accelerated. The language of the note attempts to allow the lender to have its cake and eat it too. It's seeking to accelerate the note without triggering the statute of limitations by requiring specific language of intent to accelerate, which in its own note drafted, admittedly not by Dyck-O'Neal, but by the lender, leaves it open to, leaves it permissive, not mandatory, that they may have a notice of self-acceleration. They don't know. The language of the note attempts to preserve its ability to accelerate without using that language, but effectively accelerate it sooner. Are there any questions?
Hearing none, we thank you, counsel. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The court, of course, will mail a copy of the decision to you on the date that it is released, and the opinions will also be posted on the Ohio Supreme Court website. Thank you both again for your excellent presentation.